Thanks, Jim, for that. Right, so I'm going to be talking about Japanese knotweed cases. I will mention bamboo right at the very end. When I was studying as an undergraduate, and we would do start a new applied topic area like ecology, we would always start with a lecture on legislation and the law. And I would always switch off because I wasn't interested in that sort of stuff. I wanted to know about how things worked, biology, chemistry, that sort of thing. And it wasn't until I started work as an environmental consultant that I realised that the law sits on top of everything that I did as a professional. And I think a lot of people still take that for granted, that it's the law is the reason why we're all here. There'd be no knotweed industry if it wasn't for the law and legislation. And I recall from about 10 years ago, it would have been probably, we were in an invasive weed group meeting in Huntingdon at the PCA. And I can't remember the specifics, but a member from a company had said something, and I said, look, you can't say that. If you have to stand up in a court of law, you'd have nothing to stand on if you were to have that opinion, whatever it was. And the member said, yeah, but we're not in a court of law. You know, I'm just telling my client what I think's best for him. And it's that failure for us as professionals to fully appreciate our legal accountability that I think has fueled the initial growth of the knotweed litigation industry. And it is an industry. And like any product or service in an industry, it has a growth phase, or it has a life cycle rather. So you have an introduction where it becomes a new thing. Then there's a volatile period of growth as new things are tried out, new arguments are tested, and then eventually things settle down and we reach a stage of maturity, and then eventually there'll be a period of decline. And what I want to talk about today really is that I think that this volatile period of growth, of the growth life cycle of the knotweed litigation industry, is coming to an end, and we're coming to this sort of sensible area where common sense prevails and the litigation industry has matured. So Jim mentioned there the knotweed case that really opened the floodgates, this landmark case, Williams and Wastel v Network Rail. That was 2016. And following that, a lot of law firms, litigation specialists, jumped on this bandwagon, and we had this growth phase of a lot of fairly crazy things happening. So most of what I'm going to say that will demonstrate, I hope, that I think things have settled down and we're in this maturity phase, has happened since the last PCA invasive weed conference. So there were some judgments, or that all the judgments have been pretty much, I think, in the last 12 months, maybe a little bit longer. Some of the trials were a bit longer than that, but pretty much everything I talk about now has just happened in the last 12 months. I think that's quite incredible, really. There has been a lot of change. So I think the main indicator that we are in a period of maturity in this knotweed litigation industry is the fact that now claims are a lot harder to win for claimants. So we had all these crazy cases going on after Williams and Wastel. The sun was shining, hay was being made by litigation firms, fielding all sorts of fairly crazy claims that were being settled. I think you can't get away with that now, and that's something I'm going to hopefully talk about, and you'll understand from some of the case examples. Some of you might remember, who were there, that back in 2016 we had the invasive weed conference in London, and we had a barrister from a chambers nearby. We were right in Lawyer Town, right next to Holborn and Temple, and he said at the end of his talk about knotweed litigation that if you want to be successful in a claim, then you need to go after a defendant that has deep pockets and is likely to and isn't likely to go bust. So Network Rail was the example that he gave, and it's those sorts of bodies with arguably deep pockets, they're unlikely to go bankrupt and bust. They have been the target of most litigation. That's what the lawyers have been going after, because ordinary homeowners are less likely to be able to pay out. It's of an emotionally challenging and potentially life-changing situation taking action against an ordinary homeowner. So they were not seen as easy targets. So it was these big public bodies that were seen as the targets for most litigation firms. For various reasons, which I hopefully make clear, or shine some light on, those rich pickings from these law firms have now gone. So now they're spreading their nets wider, and we're seeing much more action against and between ordinary homeowners. But that being said, there is also more action against homeowners because knotweed is a real issue. It does cause an impact on people's lives. It can involve life-changing sums of money, and because of that, people need justice. So ordinary people do need to have damages settled if they're caused. So let's just start with some case law examples that the judgment's been handed down in the last 12 months. This was probably the first one. This you might have seen this. They're all in the Daily Mail. The Daily Mail loves these. This was where the claimant had recently renovated their home, quite a nice home, and the neighbour had a vacant plot. There was Japanese knotweed on both properties, but it was the claimant's case that the defendant had not shared their responsibility in removing the knotweed from their vacant plot. It was also claimed that the knotweed had originated on the defendant's land, and that was the source of the problem. So it's just two neighbours, two ordinary homeowners, albeit in quite nice properties, well, or at least expensive land. The court found in favour of the defendant, so the person that had the vacant plot. And I think the important take-home in this case, really, for members here, is that it was apparent that the claimant's experts demonstrably were conflicted in that they had completed the treatment works on the claimant's property. So it indicated that, certainly to the defence, that there could have been a conflict of interest, a vested interest in the outcome of the claim by the contractor who was also acting as an expert witness. So what the warning there really is, as an expert, your duty is to the court. You need to be impartial. So if you are involved in contracting on a project, on a knotweed job, and you're invited to be an expert witness, that wouldn't normally happen, but it's just something to be wary of, because that is a weakness that a defendant is going to exploit, as it did in that case. Why is that not working? Oh, there we go. So another one, this was from last year. The judgment was handed down at the end of last year, I think. This was two homeowners next to each other in London. The claimant's case was that knotweed had spread from her neighbour's property onto her property, and that was agreed. But the case was that the neighbour where the knotweed came from had not done enough to deal with the problem on their property. The case went to trial. It was thrown out because the judge considered that the defendant had taken reasonable steps to deal with the knotweed on their property. And the lesson really there is that if going to court is a big deal, as I say, it's potentially life-changing amounts of money that can affect ordinary homeowners, you must have a good reason to pursue a claimant if you're going to have a chance of success, particularly if that's a vulnerable defendant, as it was in this case. I was recently at a webinar that was hosted by a barrister who specialises in knotweed claims, and he said that judges don't like holding ordinary homeowners liable for what can be life-changing sums of money. So when we're dealing with homeowners, there seems to be, in the barrister's eyes, an issue that there needs to be a higher burden of truth, perhaps, than there is in a lot of cases that affect public bodies. So, if you're involved in that sort of claim, you really do need to have a solid and reasonable claim. And one way of ensuring reasonableness in a claim is that nowadays courts are pushing for expert evidence to be produced in the form of a single joint expert. So this is what normally, or in a lot of cases that have gone before, both sides, the claimant and the defendant, will put forward a knockweed expert, and those two will then meet and batter out their differences and agree the reasons why they disagree, so that if it goes to court, that's what will be focused on. With a single joint expert, both sides agree to have one single expert who produces one report, and that's what the court judges the facts on. And because of that, it's rare for a single joint expert to go to court. It saves a lot of cost, potentially, and it also saves a lot of time. So that's why the courts like it. The courts are incredibly stretched, you might have read in the news for the last few years. So they want to do everything that they can to save time and money. So in this claim, a single joint expert was appointed, me, actually, and I was in the previous one, I might add as well. The claim here was misrepresentation. So the claimant was saying that the defendant had failed on the TA6 form when they sold the property to declare that knotweed was present on that property. And you might recognise this. It's Henderson. I haven't got the pictures, unfortunately, which you might recognise from when it did the rounds. It was quite widely reported back in January, I think. So it was decided from the expert evidence, my expert evidence actually, that the claimant must have known about the knotweed being there, and because of that, these substantial costs were awarded. Again, they're big lumps of money here. What's this, £200,000 in costs for both sides. So in this case, because the defendant lost, they had to pay the costs of the claimant's legal team as well. So that's why we're talking about big lumps of money. So, I mean, this is an example, really, that although I say that cases against homeowners particularly are getting harder to win, if you've got a good case, there's still viable claims going through. So this is Matthew White. He's head of chambers at St John's in Bristol. He is a specialist in defending mostly public bodies. And I asked him a little while ago for a quote, and he gave me this brilliant, pithy quote, not this one, because I spoke to him a couple of days ago. I said, is it all right if I use that quote? And he looked at it and he said, God, no. So he has said, let me just add some explanation to it and fill it out a bit. So don't read that. What I will do is I will interpret that in my words for what he was saying, and why this is basically why he prefers single joint experts, and why public bodies now are pushing for single joint experts to be used in claims. So essentially what he's saying is that claim firms, these litigation companies, they get their pet knotweed expert to write a fairly poor quality report quite cheaply that clearly says that knotweed spread from the defendants to the claimant's land. The defendant says to the court, come on, really, this is just ridiculous, and petitions for a replacement expert, a single joint expert who's more likely to be impartial. Single joint expert concludes something different or opposite to the claimant's original expert or their case. Claimant's in trouble for a bit, flounders, and then gives up. And that is what's happening. And I was in a case earlier this summer where precisely that thing happened. And we went to court once. It got adjourned because the claimant tried to appoint a new expert, which the judge said, no way, that's ridiculous. And by the time we were to re-attend court, the claimant had pulled the claim. They did actually say to the defendant, which was a local authority, look, let's just agree to end this claim and we'll cover it, we'll just pay our own costs, yeah. To which the defendant said, no way. And so the claimant then had to pay their legal costs as well. So again, that claim would have cost that claimant an awful lot of money. So this bullishness that you're seeing in counsel and in lawyers taking on these claims, defending these claims, just shows that that also the courts and the lawyers are much more happy to defend these types of claims now. That's another illustration of the fact that we're coming into this sort of period of maturity where there's a bit more common sense, there's a bit more balance in the way that claims are being handled, which means if they're going to be successful, they have to be good. So, to understand why, in this growth phase of the litigation industry, there was so many claims being fielded, it's probably a good idea to understand a little bit about the litigation model, where it comes from. So, in order to give justice to people, to ordinary homeowners, and litigation can be an expensive thing. You're involving courts, you're involving lawyers, it's expensive. Legal aid was there to help with the payments, to help fund the case. The law changed to make it less of a burden on the government, so to save the government money essentially, and to put the onus onto industry by way of allowing more claims to be funded through conditional fee arrangements. So this is the no-win, no-fee. So if you have a claim, you can apply to a funder to fund that claim. You don't have to pay anything. You have to pay a percentage of your winnings, of your damages, if the case is won. But if you lose the claimant, doesn't lose out. So those conditional fee arrangements, the claims are then funded through a funder. And that funder is at the end is backed by merchant banks. They put up the money to fund the claim. But of course, they're not going to lend money unless the odds are stacked in their favour. And in the terms of claims, that means that they have to understand that there is a good chance of success of the claim in order for them to fund it, because then they'll get their money back. Now, what happened was that it seems that the lenders were a bit free in lending their money to these claims and didn't do their due diligence, and consequently a lot of these claims were failing. It's not just knotweed, it's across the whole litigation area that was where conditional fee arrangements are available. So earlier this year, a large funder made huge losses when it was uncovered that a lot of the litigation they were funding had failed. So there's supposed to be around a 60–70% chance of success that they'll fund. It was in the single digits. So they ended up losing £100 million. That's just one funder. They didn't go bust because they're associated with a merchant bank, so that's amounts of money that they can cope with losing. But in the aftermath of that, after the event insurance provider went after a law firm that did a lot of knotweed claims, did other sorts of claims as well, and accused them of having not checked sufficiently that the success of the claims was high enough. And because of that, this law firm went bust just earlier this year. And you'll see at the end, it says, where I've highlighted, underlined and emboldened, case law favouring defendants meant that certain claim types were unsuccessful, meaning that high street solicitors accrued significant liabilities from failed claim types and cases. So they were pursued for tens of millions of pounds, I think it was. It's all online. There's a link there, but there's lots more online. It was quite a big deal. So that was a big litigation firm funding a lot of knotweed litigation cases that has gone belly up because they were just fielding poor quality claims. So it's another sign that if this is happening, going forward, funders are going to be looking at new claims with much more interest in how it's determined how they might be successful. So they've had their fingers significantly burnt, these funders. So going forward, claims have got to be pretty solid if you're going to get a no-win, no-fee type arrangement. So that's a bit of just case law that's just happened in this last year. Some other interesting stuff that you might have seen in the press as well are some other changes, more procedural changes to the legal landscape. This is Davis v. Is it Davis v. Bridgend? I haven't actually got it written on there. Yeah, Davis v. Bridgend. So this was an appeal decision. A homeowner in Bridgend had made a claim against the defendant, the local council, for allowing Knotweed to encroach onto his property. It was found in favour, the original judgment found in favour of the claimant. The defendants appealed that decision. The appeal failed earlier this year. The defendants having another go by taking it to the highest court in the land, the Supreme Court, which is going to be heard in January, I think. So it's an appeal against an appeal. Now, the appellant here is actually represented by Matthew White here, so the defendant and the counsel. And as an interesting side note, I actually did the original report for the claimant on this case. Matthew White, who was opposite, petitioned the court to have my evidence not considered because I was biased as I was working for the claimant, which is to the model that he was talking about. And a single joint expert was used. But the single joint expert essentially said what I said. So the matters of fact on Knotweed aren't part of the case. The crux of the issue that is going to be tested on this, that could have an impact on all of us, is, or at least all of us involved in Knotweed litigation, is one of legal principle about when was constructive knowledge placed on the defendant. So it was said that the Knotweed has encroached in the 2000s, but the date of constructive knowledge that was agreed in Williams and Wastel is 2012, because that is the date of the RICS information note. So that means that before that date, it's arguably reasonable for a defendant not to have known about Knotweed as an issue. So that's what's being tested. So if it's found that, yes, any Knotweed encroachment before 2012 isn't anyone's fault because we didn't know about it as a problem, and again, you can argue about that, and it probably will be argued about, but this case could set a precedent on that issue, and it's going to be heard in January. It could scupper many claims if it can be proven that Knotweed had encroached onto a defendant's land before 2012. So this is another one that was heard in the Court of Appeal just last week, actually. This, although it's a Knotweed case, a Knotweed encroachment case, that is of less interest to most of the people that are following it, because it has the potential to significantly change how litigation is heard. And as an example of that, or to illustrate that, the third parties represented, the interveners represented in court last week at the appeal court, was the Bar Council, the Law Society, the Civil Mediation Council, the Centre for Effective Dispute Resolution, the Chartered Institute of Arbitrators, Housing Law Practitioners Association, and the Social Housing Law Association. That is a lot of wigs in the courtroom, which you would have seen if you'd live streamed it, as I did a little bit last week. But it shows you that it's a huge issue. What is being argued is that should a Knotweed dispute, well, in this case it's a Knotweed dispute, but it could set a precedent across all litigation. Should alternative dispute resolution, so in this case it's a council's complaints procedure, be fully exhausted first before any legal action can be taken in the courts? Now, it sounds like a sensible idea, you'd think. In the House of Commons Select Committee on Knotweed, one of the recommendations of the final report was that ADR, alternative dispute resolution, should be the main mechanism by which Knotweed disputes are heard and dealt with. So this is an example of that. The trouble is, I mean, well, when ADR works, it's great. And ADR is a very wide church, very broad church. It can be anything from a council's complaints procedure up to getting a professional mediator involved to sit down with the parties. But it's not in court. So when it works, it's quick, it's cheap, and it doesn't involve lawyers. But therein lies a problem. if you have a homeowner who is not properly represented by somebody who knows the law, they could get rolled over in a council meeting. The council meeting is a lot less austere, serious setting than in a court. So people are much, it's much easier for people not to tell the truth or the whole truth. They're not under any obligations. So people who are trying to settle disputes, ordinary homeowners, might not realise that they, or they might not get proper justice. They might, they might be pushed around perhaps and not actually get a reasonable settlement. So lawyers obviously will want to go to court because they get paid. But defendants might quite like this sort of process because they won't be exposed to adverse costs. So if if they were to lose a case, a claimant's to win, in a court, they would be exposed to having to pay the claimant's costs, which are, as we can see, those are big lumps of money. So with an ADR process, if it becomes compulsory, then they wouldn't be exposed to those costs. So defendants might like it, but lawyers probably don't because they won't get paid. Another issue, just last month actually, was a change to the legal procedures. So we now have this intermediate track, which is the process through which you push litigation. So there's also the fast track. We had the small claims track and then the multi-track. So small claims is for small claims, and multi-track is for everything above that. So quite big sums of money can be involved. So we now have in the courts this intermediate track. This is, it places a lot of limits on how litigation is organised, which means there are limits on cost and time, length of reports, that sort of thing. It sits between the small claims and the multi-track, the small claims track and the multi-claims track. It's limited to all claims below £100,000. So that's probably most, or many, maybe not most, many if not most, knotweed claims. It could make claims less profitable because it sets these limits. So it could make it less profitable for a lot of these claims firms that have been fielding lots of claims. So, you know, that might be a good thing, I don't know. It has another impact on lots of people involved in the court, so experts as well. It's all quite new. A lot of professional bodies for lawyers and for experts are up in arms about it because it could make significant changes on how they get paid more than anything. Another thing from the Select Committee report on knotweed was a legal review. A legal review was commissioned to see how knotweed legislation and law is dealt with in other countries outside of the UK. And the findings of that report were that while knotweed litigation in the UK is unique to that country, there were signs that other countries were probably going to follow suit. This is from America. It's Middlesex, Massachusetts, not different Middlesex. But it's reported to be the first knotweed litigation case involving private landowners in the US. So is this the first rumble of an avalanche of knotweed litigation in probably the most litigious country on earth? Don't know, but I wouldn't be surprised if you'll see more follow from that. So I was at Jim's brilliant bamboo webinar a couple of weeks ago, thank you. And I'd mentioned a comment at the end of that about bamboo, and I said that the Law Society had told me, because I was asking them about this issue, that they would consider adding bamboo as a property risk to the TA6 form if they were, if bamboo was to be included as a property risk within the UK finance lenders, UK Finance's Mortgage Lenders Handbook. And the only way to get a change to that handbook is for a professional body to lobby them, to let them know that they think, that a professional body thinks that that should be included as a risk. So, if you, as members of the PCA, consider that bamboo is a real and serious financial risk to property, so that it could be included on the TA6 form, then bother the PCA, and Daniel in particular. He's waving, he's on it. But yes, but basically, so it could happen. Whether that's a good thing or a bad thing, that's up to you as members to petition the PCA to lobby UK finance. I'll just finish by rounding off with the statement that although there have been a lot of knotweed cases in the past that haven't been perhaps particularly robust, and things are changing now. I think we're in this maturity phase. There still are many knotweed claims that are right and proper. Knotweed causes a considerable financial impact on ordinary people, and justice needs to be served to them when it's appropriate. But what has changed is that poor claims by opportunistic law firms, supported by poor quality expert evidence, are falling away. And I think that can only be a good thing. Thank you.